Hi, everyone. I see you guys starting to log on. Thanks for joining. We're just going to give everybody a couple minutes to get logged on, and then we'll get started. Thanks, everyone, for joining. For the sake of time, I'm just going to get started right now. But my name is Cecilia Mortar, and I'm the programs manager for the Steamboat Springs Chamber. I want to thank you guys all for joining in our first session of the Creating a Culture of Retention series. A few housekeeping items. If you can please make sure to use the Q&A for chat. It'll be the toggle on the bottom of your screen. It helps us filter them. And if you want to just put in any commentary in the regular chat, that would be great. We're here today with Tina Harkness from the Employers Council. They have been supporting employers in Colorado for over 80 years now. They have 200 HR and legal professionals who are here to connect you with the services, resources, and training opportunities that your company needs to thrive. And with that, we've got a lot to cover. So Tina, I'll let you take it away.
Thanks, Cece. I'm going to go ahead and share my screen and show some slides. We're going to be talking about employee manuals and a little bit on operations manuals, but we'll focus on employee manuals or handbooks with our time here today. At Employers Council, we provide sample handbooks and sample policies. We review them for our members. I've been working on handbooks for the last 20 or so years. So, we've got a lot of good data to provide to you today, a lot of good experience behind what we'll talk about. And as Cece said, if you put your questions in the Q&A, then she'll help me keep track of those. I also have some information from Cece for questions that you all provided beforehand about PTO and paid sick leave. And I know you're curious and maybe a little anxious about the Family and Medical Leave Act initiative. So we'll talk a little bit about that with what we know. But I'm going to go ahead and share screen so you can see some slides. All right. And Cece, how's that looking? Are you seeing slides or are you seeing slides with notes?
Slides with notes.
Okay. How about now?
Slides, perfect.
All right, great. So we're going to start and just with the why of having an employee handbook. You don't have to. There's no legal requirement to have it. Many employers do, however, find that there's some benefit to having an employee handbook. And I know this is part of a series on employee retention. Having some foundational pieces in place, I think, is one of the puzzle pieces to employee retention. And a handbook serves in all these areas for part of your communication to your staff. It certainly can be supportive of the culture that you're trying to create in your workplace. Again, give people that foundation and be a reference for both you and your employees. So sometimes we have a hard time remembering, well, what do we do in those particular circumstances? Maybe they don't come up that often. And for most of employment law matters and for most of our employee relations pieces, we want to try to the extent that we're able to do so to be consistent. And a handbook can help us do that. An operations manual, well, what is that, first of all, and how is that distinct from an employee handbook? The handbook is really your guidelines that all employees need to know to do their job. An operations manual is typically the step-by-step procedures that are really too detailed for the handbook, that go well beyond a guideline into this person has responsibility for X, this person has responsibility for Y, this is step 1, 2, 3, 4, 5, however many. It might even include some forms or some linkages to other documents that you have in place in your workplace. So an operations manual is just another place that you can put those things that you do in your business that aren't necessarily guidelines for employees, but are still information that people with roles in those processes need to know and follow, again, from a consistency place. So for example, I'm working on our internal employee operations manual. I did our employee handbook at the end of last year. And so a policy for our operations manual is like expense reports. So in the handbook, it might say, we reimburse for expenses with receipts. So that's really all employees need to know. And then the ops manual side of that is you go to this place on our intranet and you get this form and you fill it out in this way and you give it to accounting, and then accounting does this with it. And then this is how you get paid for your expenses. So that might be an example of a contrast between the same topic, but what you would put in an employee handbook and what you might put in an operations manual. As I mentioned, there might be different roles in that operations manual, where really in the employee handbook, there's just one audience, which is your employees. And it can get into that nitty-gritty in the operations manual that we really try to avoid in the employee handbook, so we're not having to revise it and change it every time those nitty-gritty pieces are altered. As I said, it promotes consistency. And as we're seeing with a lot of people exiting our workplaces, the turnover that most companies are experiencing, an operations manual can really help avoid loss of that institutional knowledge. So especially if you've had people at your companies for long periods of time, they don't know what they know sometimes. And you don't know what they know until they're not there anymore. And then you're wishing they were, so you could ask them. It would be a good thought, if you have those kinds of situations, to try to do a little bit of a brain drain with those long-term employees to see what procedures and processes they have in their head that we maybe don't have written down someplace, so that we don't lose that information when they leave. With handbooks, the most common employment dispute we're going to run into by far is an implied contract claim. So implied, because the handbook itself hopefully is not found to be a contract, although we sometimes do see contract claims based on handbooks. We try to avoid those. But an implied contract is another document or another agreement that has elements of contract, but maybe we didn't formalize it. So we're trying to, obviously, as an employer, avoid the finding of an implied contract based on our handbook. So there's certain things we want to do to put us in the best position if some employee does make a claim that our handbook is an implied contract. Most important, and on the top of this slide, is having a disclaimer and an acknowledgement. So the disclaimer is usually front and center. The first thing you see when you open that electronic handbook, or if you have a paper version, it should be the first page, maybe right after your title page, or near to the very beginning. So it's prominent. We like them to have even bold capitalized type. And we'll talk about what should go into a disclaimer and an acknowledgement. So the disclaimer kind of tees off the handbook, and then the acknowledgement is the closing of the handbook. So it's the same language generally, but in the disclaimer, you're just declaring these items. The handbook's not a contract, employment is at will, and those things. But then the acknowledgement will be the employee saying, I understand that the handbook is not a contract. I understand that my employment is at will. So they mirror each other in their contents with a little different wording. We want to also avoid implied contract claims by not using contractual language within the body of the document. So some things we run into are things like references to cause for taking certain actions. Well, cause seems like a pretty innocuous word, but it's a word that people go to court over. What is good cause? What is just cause? Really, in an at-will employment relationship, we don't have to have cause for taking certain actions. So we shouldn't bind ourselves in the handbook to having to have cause. Also, I often see words like entitled or entitlement. There certainly are some things that you're going to cover in the handbook that are legal rights, but for many things, they are not. They're benefits that the employer voluntarily provides, or their policies that you don't have to have. So you really want to limit use of entitlement or entitled to just those legal rights. And you don't want to bind your workplace to a lot of deadlines or a lot of specific actions. Sometimes I'll see, that the employer has to respond to an employee complaint in writing within a certain number of days. Well, there's no law out there that requires that. So maybe you don't put yourself in that box because you may not always be able to comply with those kinds of things. So we want to avoid contractual language. Sometimes I'll even see language that goes into contracts, into handbooks, talking about terms and conditions and agreements and those sorts of things. We want to avoid those. Another common claim from employees about their handbook is that there is a list of terminable offenses. So disciplinable or terminable. And sometimes it's a very long list. And I know you like to make sure that employees know, what could be problematic. That's part of the handbook. And at the same time, sometimes employees will argue that those things are exclusive lists. If you got 42 items listed, it's kind of hard to say that, and there's more from the outside looking in. So we try to avoid lists of terminable offenses. If you do have a list, make sure it's a short list and make sure you're not already covering it someplace else in the handbook. A lot of times I see these lists that really regurgitate what's in other policies in your handbook. And it already says in those policies that this kind of behavior is not tolerated in our workplace. You don't really need to list those things again. Probationary periods. So when we're talking about an at-will employee, so that's a person that's employed for an indefinite period of time. They're not under a contract. So that is most employees in Colorado, most employees in the United States. That's me. That's probably you. We're probably all mostly at-will employees on this call. We want to avoid with those at-will employees a probationary period. So that is that usually at the beginning of employment, those 30, 60, 90, whatever you guys come up with as the number of days that the employee has to learn their job. And then the question becomes, when you set up those probationary periods, what significance does that hold? Or if you get through the probationary period, what happens next? The implication is that, or the worst case scenario, right, is an employee who argues, well, I was just at will during my first 30, 60, 90 days. And then you have to have good reason to fire me. Then something changed because I had this probationary period. Also, we sometimes have employees who we know right away aren't working out. And we want to end things sooner rather than later with those people. Well, if we've given them 30, 60, 90 days to learn their job, there's an argument that we have an implied contract for letting them try to fulfill our requirements through that period of time. And we don't want to waste our time on those kinds of things. So stay away from those probationary periods. You have expectations of employees every day they're on their job, and they're different day one from day 101. But there is no legal significance or magic to setting out a probationary period. You can still be sued if you fire someone day one as if you let somebody go day 101. So you might as well not give them opportunities to make an implied contract claim out of a probationary period. And then we certainly don't want any employment agreements in your handbook. You'll see in a minute what needs to go into a disclaimer, but one of the things is nothing in this document, right? Nothing in this handbook is a contract or an agreement. So don't put any agreements in there because then you really can't say that. For handbook format, crucial things are a handbook date, right? Because we revise our handbooks from time to time and we want to know what handbook was in effect, right? Because as of that handbook date, the old one is no longer effective and the new one is effective from that point forward. So that gives us a line of demarcation. So some employers just put that front and center on the title of their handbook. Some employers will date each page, and that's more for those employers who substitute in different policies at different times and want to track, how recent that particular policy is. If you've got a small handbook, you can probably just have one handbook date for the whole thing and just replace the previous version each time. If you've got something more lengthy, you might choose the other method. A title page. Again, you might have an electronic handbook, just something that introduces you to the handbook. So you're not diving right into the content that gives employees the notice that this is what they're getting into. If you've got a handbook of any length, the table of contents is helpful so that people can get to what they need to quickly in the handbook. And then we recommend, your group like policies together. You do some kind of logical order so people aren't jumping around in the document, either electronic or paper, to try to find things that go together. Again, these are guidelines. You do not need to try to cover everything. I have certainly reviewed some very lengthy handbooks in my time, and maybe wondered as I was reviewing them if this was really serving that business very well, because the employee probably wasn't reading the whole thing. I was being paid to read it and comment on it and help you guys with them, but the employee probably isn't going to read, a 50+ page handbook and really and have it work for you to make sure that they have the foundation that they need, that they get at least some of their questions answered, so they're not always coming to you with those foundational items. Few things every handbook should have. This is Colorado. Of course, the date, we talked about that. Disclaimer and acknowledgement, we talked about that. Another key piece is your anti-discrimination, anti-harassment, and anti-retaliation policy. So this is sometimes called your EEO or your equal employment opportunity policy. This court decisions have said every employer needs to have. Again, based on your size, you may only be covered by Colorado law, or if you are larger, you may be covered by federal laws on top of that. So the contents of that policy will change a little bit as far as what statuses are protected, but the basics that we prohibit discrimination, that we prohibit unlawful harassment, that we prohibit retaliation for bringing forward a complaint, either on your own behalf or someone else's, those key pieces are going to be there, as well as your complaint procedure, right? Who do people go to? Preferably having more than one option, although sometimes with smaller employers, you really don't have multiple options of where people will go. Colorado also requires pregnancy accommodation, and that is part of our civil rights law. So this is more than just not discriminating because someone is pregnant or could become pregnant, or this is actual accommodation. So if the person is facing a workplace barrier due to pregnancy or some pregnancy-related disability, it's an advisement that will engage in an interactive process with them to try to figure out what can be done to accommodate them and still allow them to perform their work. So we need that in there. We really do recommend an internal problem solving policy. So just who do they go to if they have a question, a dispute, they disagree with something that's happening in the workplace. And this is to hopefully avoid, the immediate going outside of the company to an agency like the Colorado Department of Labor and Employment or the Colorado Civil Rights Division, or the like. Because if there are issues in our workplace, which could come up, we'd like to know about them. We'd like to have the first crack at seeing if we can't resolve that to make things better for that employee. It might not just be that person that's affected. It might be something we need to just clarify. And so the internal problem solving is for that reason. And some of you had questions about Colorado's requirements for paid sick leave. Of course, we had the Healthy Families and Workplaces Act pass and go into effect for employers with 16 or more employees in 2020, but for all employers in 2021. So we're now having to provide paid sick leave to all employees of our organizations. If you're a federal government employer, you can ignore that part of this, but I don't know that we have any federal agencies on the line. But we'll talk a little bit more about paid sick leave as well. We want to have a safety reporting of injury piece. All of you who have one or more employees need to have workers' compensation insurance. So you're going to have a policy that talks about reporting injuries or illnesses that the person thinks might be connected to the workplace, no matter how minor, and to do that in short order. There was a bill that passed, I believe the governor has since signed it, that changes the 4-day threshold for reporting for employees, I think, to 10 days to give them a little bigger window. But we're still going to want in our handbook to tell them to immediately report. And that law, you'll get more information on as it goes into effect later this summer. We also recommend having a exempt employee salary deductions policy. Why is a question I hear a fair amount. And that's because exempt employees don't get paid overtime. And as a trade-off to that, there's only certain deductions that can be made from their pay. And it's kind of confusing when you can dock exempt employee pay. So the Department of Labor at the federal level has said employers that have policies that say, if we make a mistake with our deductions from exempt pay, please let us know. If you have a written policy to your employees to that effect, then you get a chance to fix it, which you definitely want, because again, it's a confusing rule and sometimes we get it wrong. We want a chance to fix it so that we don't lose exempt status for that employee or anybody in that same position, and then be in a situation where we might be paying them overtime because they're no longer considered an exempt employee. And then for private employers, so that's nonprofit, for-profit. It is not government or the special districts that I'm talking to here. So private employers are subject to the comps order in Colorado. And that used to be called the minimum wage order until 2020. They changed it to the comps order because it's expanded for beyond minimum wage for some time, but they finally got around to changing the title. The comps order now requires, if we have a handbook for our workplaces, we need to either put the order, which is 20 some pages long, or the poster, which is 1 page, which is what we recommend, in the handbook with its own acknowledgement of receipt. So when you republish your handbook, if you haven't done that since 2020, and you are a private employer in Colorado, you're going to put the poster and a separate acknowledgement in that handbook for the comps order. Coming back to the disclaimer and acknowledgement for just a minute. what goes into that disclaimer and acknowledgement? Well, we want to make sure it's very clearly written. So we're not using legalese, even though you have an attorney in front of you. We try to use very plain language with these. We want it conspicuously placed, like I said, after the title page in a paper document or at the front and center in an electronic document, if that's how you have your handbook these days. It's going to say that the handbook is not a contract, right? To avoid those implied contract claims. Assuming you are at will, because most employers are, it's going to say employment is at will and have a small description of what that is. And then it's going to say that the company, right, or the organization, if you're a nonprofit, that's usually how you word it, gets to interpret the guidelines. And that they can be changed, they can be rescinded, they can be altered really at any time as the company needs to, except, of course, for at-will employment. And then we also throw into our acknowledgement and disclaimers that if you did have a contract, it would have to be a separate written document from the handbook, and it would have to be signed by usually the top executive in the company and the employee. And the acknowledgement usually says, and we've not done that. So that usually is usually what goes into that. For your anti-discrimination, anti-harassment, anti-retaliation, right? There's going to be a long list usually of protected statuses. And the federal protected classes are listed at the top of this slide. We also have the Colorado protected statuses. So gender identity, gender expression were added in the last, not the current, but in last year's legislative session for Colorado. And hairstyle associated with race. That's the Crown Act. If you might have heard that mentioned. There is a debate on making that a federal law at this point, and I believe it's maybe passed one of the federal houses. But it's kind of harder to get things through our federal Congress, as you can imagine, especially in a midterm election year. And the closer we get to that cycle, you know, the less that happens, the less focus that's placed on that, let's say. Also, we mentioned the complaint procedure and the anti-retaliation language that needs to go in there. Internal problem solving, right? I mentioned this earlier. We recommend having it. It's not a legal requirement, but it's an invitation for employees to bring problems to you to try to resolve, again, at that lower level. So they don't have to go outside the workplace to get help, which can be fine too, but is a little more complicated when you have another party involved that has their own interests in how a situation gets resolved. And it helps surface potential problems. We do want to know, again, if there are problems lurking in our business, if something's impacting employees in a negative fashion. I think most employers would agree. We'd rather know about it and see what can be done about it, if anything, or provide some further explanation about why it's that way if employees don't like that very much. Because again, employees do the business of our business. You know, we're all scrambling to get people right now. We're all scrambling to get and keep skilled people right now. So they really are crucial to everyone's business. So I mentioned, I just got ahead of my slides, Cece. I do that all the time. Sorry, she's laughing at me probably. So the safe harbor policy I mentioned for protections from exempt employee deductions. Why do we need that? That gives us a chance to cure and protects against loss of exempt status and potentially back overtime being owed. I suppose if you didn't have any exempt employees, then you might not need this, but most employers do have at least one exempt employee. So comps order, again, private employers only. There's a lot that goes into the comps order, including minimum wage, but there's daily overtime, meal and break periods. what deductions are permitted or credits from wages or charges. And then it does set for exempt employees a higher salary level, again, for private employers in Colorado than is required at the federal level for someone to be ineligible for overtime. So that's what's in the comps order. The notice does have to be included in the handbook with its own acknowledgement and posted. That's the other thing I didn't mention earlier. It also gets posted with your posters. You can do that electronically on your intranet that all employees have access to, if that's the case, or you can do that physically in your workplaces. So paid time off. So CC sent a lot of your questions, and they, not surprisingly, were around paid time off. So one of the questions was around, do we have a separate sick and vacation or a general PTO? And I'll just tell you that we've surveyed employers for years on this question. And looking at our 2020, that's our most recent paid time off survey, it's about half and half. It's really darn close to half and half of employers that have separate sick and vacation and general PTO. So I would just say general PTO seems to be the more modern approach, right? It's more flexible. Employees can use the time as they wish. They don't have to fit it into one bucket or the other. What's complicated this a bit is the Healthy Families and Workplaces Act, which requires employers to have accrued paid sick leave. Now you can grant it, but there's a paid sick leave component to it. And then there's the public health emergency leave, which is also paid, but is COVID specific. That will eventually go away, the public health emergency leave. It's not gone away yet. Right now, we're looking at like mid-May, if there are no further extensions of the public health emergency for COVID-19. And I say if, and I'm laughing a little bit because there have been 7 or 8 extensions to this point. So please don't hold me to that there can be no extension at this point, because it won't work to do that if the government does provide an extension. But the paid sick leave portion, that's ongoing. That's going to survive COVID. That's not COVID specific. The Colorado Department of Labor and Employment and the Act do say that you can use a general PTO policy to satisfy the Healthy Families and Workplaces Act. But if you do that, you have to make sure your general PTO policy conforms to all the requirements of the Healthy Families and Workplaces Act. And that does take away some of that flexibility of general PTO, because we do need to know that the person is out for illness or for a Healthy Families and Workplaces Act reason. They can't just say, I'm using PTO today, like they could prior, because we are supposed to be tracking both the accrual of leave under Healthy Families, which isn't hard. We have our PTO accrual tracked, but then also the use of Healthy Families leave, which, you know, again, we would track that PTO is used generally, but when PTO is used for a Healthy Families and Workplace Act reason, that's another piece of the record keeping. So I have seen some employers shift back. It's not a lot, but I have seen some employers shift back from a general PTO to sick and vacation. Another reason for that is that sick leave does not have to be paid out at separation. But if you've got a general PTO, right, you do need to pay out any unused leave at separation. And that is for private employers. Again, let me be very clear about that. Public sector employers, you can stop listening for a few seconds, but for private employers in Colorado, so nonprofit and for-profit entities, you do need to pay out any general PTO that's unused at separation, and any vacation that's unused at separation. So when you have the split, sick and vacation, the vacation tends to be a smaller, right, chunk, whereas general PTO is the bigger one bucket. So that is another reason that a lot of employers have kept their sick or vacation, or maybe chosen to go back to sick or vacation. Jury duty, you gotta pay that. As any employer, we pay the first 3 days of jury service for your non-exempt employees. For your exempt employees, you pay all of their jury service unless they miss an entire work week and perform no work that entire time. And that's unusual for jury service. And then voting, again, with our mail-in ballot system, this is generally not an issue, but Colorado does have voting time that needs to be paid up to 2 hours if the employee makes arrangements prior to the day before election day, and the employee does not have 3 non-consecutive hours between 7 a.m. and 7 p.m. when the polls are open to go vote. Right. Again, this doesn't come up much, and it's a nitpicky little rule, but that is the rule on voting time for pay. Other common areas that are covered in the handbook, under the conduct kind of category: alcohol, drug, what's okay, what's not okay, anti-violence, what's okay, what's not okay, attendance, pretty frequently covered there. Do people have to call in? What is the situation? Technology is increasingly more part of our work lives. So your policies might deal with social media. Certainly they may deal with email or internet use, or employer equipment. More and more of those questions coming up with people working remotely with employer equipment. Business ethics tends to be a section in a lot of handbooks. So it could be confidentiality, conflicts of interest, could be for nonprofits particularly, you might have a whistleblower policy. That's pretty common in that subset of private employers. And then leaves of absence. So one of the questions CC got before this session was, what's common for parental leave for small employers, I think was the question. And I looked at our surveys again. The most recent paid time off survey we have is our 2020. So 2022 must be coming out at just about any time is what I'm thinking. But our survey said for Colorado employers who responded to our surveys, again, so it's not all Colorado employers, 26% of respondents that had 1 to 49 employees had paid parental leave. So it's a smaller percentage, less than a third of employers at that size having paid parental leave. Again, there's not currently a requirement. We will talk about the Family and Medical Leave Initiative at the end of this session. There's not currently that requirement. That leave that was voter approved is going to go into effect benefits are going to start getting paid in 2024, January 1, 2024. The tax deductions will start a year earlier, January 1, 2023. So again, it's 26% of employers had some paid parental leave. And for 43% of those employers, that was available immediately to employees upon hire. 54% of the employer offered paid parental leave after a certain number of days, months, or years of service. So we didn't get any more specific than that in our surveys, but that's just a little information about what might be out there. So here we are with the Family Medical Leave Initiative. So this website is going to be your friend if you are an employer in Colorado. Well, an employer, let me start there, with 10 or more employees anywhere, not just Colorado. You're going to be covered by the Family Medical Leave Initiative. If you have 9 or fewer employees, then you are not. You don't have to participate in this program. So this is the voter approved leave that we were talking about. And I mentioned that payroll deductions are going to start in 2023 and benefits won't begin until 2024. This is going to be a state system. And I attended a webinar that they held earlier today. Some of you might have gone to that, trying to answer questions about family. And they don't have it all worked out yet, but the Colorado Department of Labor and Employment has created this website. They are providing recordings of the webinars that they're doing about family. They're trying to chunk it up into digestible chunks. They have some upcoming webinars on April 29th. They're going to do one for local governments because local governments can actually opt out of participation in the Family Medical Leave Initiative. Now, so they could opt out as the employer from the employer contribution. Their employees can still opt in though, so they still need to know how to work with this system. And so they're doing one on April 29th just for local governments. And then there is one for small business. So I know a lot of the folks that are members of the chamber who attend these webinars are smaller businesses. So May 27th is going to be your date for small businesses and family, what you need to know about that act. And then they are going to do one June 30 about calculating the premiums because you're going to be, if you're covered, you're going to be contributing as an employer. An employee is going to be contributing from their paycheck towards funding this system. That's why the deductions are going to start in 2023 so that they can build up money into that fund to start paying benefits in 2024. And there's a lot of that is yet to be determined about family. I will tell you that the session today was an hour long and they presented about 15 to 20 minutes of content. And it was on interaction with family and the federal Family Medical Leave Act for those employers who are covered. And the rest of their time, 45 minutes of that time, was answering questions. And they did not get to all the questions by the end of that hour. So again, they're recording their webinars, they're recording the Q&A up to the point they cut that off. And then they say that they're going back through the Q&A and grabbing the questions that they didn't have time to answer and putting that into their FAQs page. So you're going to want to explore this and maybe attend or watch some of the recorded webinars to determine the impact on your business. You're going to need to update your handbook. And the Department of Labor has already created some language to explain the payroll deductions. They don't, from what they said today, have the integration with the Federal Family Medical Leave Act, if that's applicable to your company, figured out as far as the writing. But you're going to need a policy on that. So that person who asked about parental leave, right? What's usual for small employers to provide? Again, if your company has 10 or more employees, you're going to pretty soon have a state system that's going to provide leave for birth and care of a child, also adoption or foster placement of a child, or any serious health condition that a child might have. So there was something coming. The Colorado Department of Labor and Employment is really trying to fashion this system similar to unemployment, because that's another state funded system, right? That individuals draw from when they have certain qualifying events. They're trying to, and they talked about this a lot today, fashion the employer reporting parts and the tax reporting parts after the unemployment system to make that easier for you all, since you may be used to the unemployment system. But again, there's a lot yet to be worked out on family. They do have a benefits calculator that they've got stood up on their site. They're going to have information on the local government opt-outs available there. And they did say, they did talk a little bit about private entities, private employers. If they wish to opt out, they can do that only if they have private insurance that they have purchased that provides the same or equal benefits to the state system. And you have to get approval from the state of your plan to opt out. So the Division of Insurance is also in on family, and apparently they have just put out some announcement very recently to say that carriers who want to file plans with the Division of Insurance to sell, right, to employers to comply with family, can do that beginning in November of this year. And then they will review them for family compliance and communicate back to those carriers, yes, this works, or no, this doesn't work. And then employers will be able to start purchasing those plans if they wish to do that after that time, to use that as a substitute to participating in that program. So if you do that, if you do go that route as a private entity, then you will not be contributing to the state fund. You will be paying your premiums for your insurance instead. So that is still in its early stages, it seemed like, from today's conversation. But that is also information that is going to be firmed up as we go down the line. So let's see. Common problems with handbooks. Yeah, getting into the weeds or trying to cover everything that might come up in a handbook is a common problem. Again, because the handbook just grows and grows. And you really want to try to cover general things that are applicable to all employees, not the little wrinkles that maybe you didn't specifically account for. And that's also why they're guidelines that we get to interpret, because we can decide, yeah, this fits there. Maybe you didn't understand that to fit their employee, but we do feel that it does. And this is an issue, and this is what we need to do to correct it. I also don't want you to think that you have to have a policy for everything in order to act on something. That's definitely not true. So an employee saying to you, well, that's not in the handbook, or is about as effective as saying that's not in my job description. You know, the employer gets to set the terms and conditions of employment. And yes, while we try to cover most things that we think will come up as job duties in the job description and will come up as guidelines for the handbook, we're not going to get to everything. And we'll still deal with those issues that come up as one-offs. I want to caution you against borrowing a handbook from another organization. I know that happens, and I know why that happens. These are not, though, one size fits all. And I have seen situations where smaller organizations particularly have borrowed handbooks from much larger organizations that have stuff that doesn't even apply to them because of their size in that handbook. And that's not helpful to you if you have taken on more obligations in writing to your employees than you actually have legally. So going back to my first slide on implied contracts, I probably should put that in there as a bullet. If you put in your handbook that we're subject to this or we follow this, and you don't have to, then there's an argument that the employee could make that based on that handbook, you should be following it. Again, if you have stuff that applies to just a small grouping of your employees, then you can provide that separately to them. You don't have to put it in the employee handbook. I mean, I know that's a lot to keep track of, and it's cluttering up that handbook that you're already, fighting an uphill battle to get employees to read. So I would provide those kinds of pieces of guidance separately, put the operational guidance in the ops manual, or you can have them be standalone, whatever it is for your company. For those of you who use volunteers and independent contractors, it's crucially important as an attorney talking to you, for me to tell you that we do not want them to confuse their status. Volunteers, unpaid volunteers are not employees. Independent contractors are not employees. So they shouldn't get your employee handbook, and you shouldn't have to provide guidance to them in your employee handbook, because that's just going to confuse the relationship you have with those people. And you really don't want them to be confused about what relationship they have with your organization. So let's see. Somebody asked in CC's questions about seasonal employees and what's typical for benefits. Well, our survey data, again, indicates that it's not typical for seasonal employees to get benefits. Most employers do not provide benefits to seasonal employees. Now, I understand that employees are hard to come by. Seasonal employees are hard to come by. Resort area employees are hard to come by. Rural area employees are hard to come by. So you might want to provide some benefits as a differentiator to you. If you're a small organization, fully insured benefits might be too costly at your size. So you might think about some things like paid time off, vacation for those folks, because that is something that many people find attractive when they come to work for an employer. There may be some other things, ski passes or things along those lines that you're able to subsidize or assist with that attract and hopefully retain and bring back your seasonal folks. But it really isn't typical to provide benefits. Of course, the exception now is the Healthy Families and Workplace Act leave. The paid sick leave and the public health emergency leave also have to be provided to temporary and seasonal folks. It's just maybe a lesser amount because they're not working as many hours or they don't work as long. Cece, what other questions do we have in Q&A or in your email to me?
Yeah, in the chat, we have a question on if you have any information for the current COVID accommodations.
So COVID accommodations. So if we're talking about public health emergency leave, I mentioned earlier that should still be available to your employees because the public health emergency is still in place. So that is the COVID specific leave for full-time employees. That was 80 hours of leave. For people who work less than full-time, it was less than that. And again, it's a one-time allotment that you needed to give them January 1 of 2021. And that's there's no renewal of it for 2022. Once they've used whatever they were allotted, it is gone. So if that's what we mean by accommodations, then that is the public health emergency leave requirement. So if that person's on the call and you want to elaborate on that, I would be happy to see if I can answer further questions about COVID.
It sounds like you covered it to the extent that you wanted. So we're all good there. In the questions from before, How does HFWA interact with substitute teachers? Is it a requirement to offer sick pay for an employee that doesn't have a set schedule?
Okay, thank you. I did see that. And so I would say yes, because it is all employees, and substitute teachers typically are employees in my experience. So, but since they don't work all the time, the amount is going to be difficult to determine. So there is a formula for variable hours employees that who need time off for healthy families. And that's what I would follow. And I think there's two options: that you base it either on their scheduled time, which these people don't have, or on their actual hours worked. So that's probably how you're going to have to calculate it, is based on their hours worked. And it's usually, I think that the requirement is to do that calculation like at the time they need the leave. So you would have a little bit of a look back to figure out what they've actually worked to determine what time you need to provide to them.
Okay. And then one more in here has to do with leave if it's going to shut down the business. Is there anything that employers can do there?
Well, obviously, if you shut down, you don't have to provide the leave, but I know you're trying to avoid shutting down. I did have that come up as a question, like we don't have enough staff, so we're not able to be open certain days or certain times. If that's the kind of shutdown we're talking about, then paid leave doesn't have to be provided for the time that your business is not open. But if we're talking about the hardship that paid leave imposes on your business, that unfortunately I don't have a great answer for, because again, Healthy Families and Workplaces covers all employers, regardless of size. So it is saying you do need to provide that paid leave. And it is something that an employee could make a wage claim over. So you're going to want to do as much as you can to plan for that ahead of time to avoid that economic hardship to the extent you're able.
Perfect. The rest of them were very much sick and paid time off focused, and I think you covered that pretty well. For the rest of you, if you have any questions right now, feel free to put them in the Q&A. There's also on this last slide some information if you are looking for additional questions answered from the Employers Council. I want to thank you all for joining today. We do have a few more sessions in the not so distant future. Our second, Creating a Culture of Retention, is focused on how to implement family forward solutions, and that's on April 13th. Tina is going to join us for an employment law update May 26th, right after the legislative session ends, which will probably be helpful for a lot of you kind of looking to work on your employee handbooks. And then her colleague Sue Wolf is going to lead a session on resort survey analysis of benefits and compensation, and that'll be July 21st, and it's the third part of our Creating a Culture of Retention. It looks like we've got one more question or a couple coming in. How can we effectively offer benefits for part-time?
Well, like I was saying, if you're a small employer and fully insured benefits are out of reach financially, you might try to offer some voluntary benefits like paid time off, like I mentioned, maybe subsidizing a ski pass or something like that. That would be attractive to an employee. I mean, you can shop the Colorado Marketplace for health insurance, and certainly talk to brokers. That's the big ticket one, right? Is health insurance that people value, or many employees value. Not everybody. I shouldn't be too general about that, but oftentimes that's cost prohibitive. But maybe some other things are less so. Some other insurances. So that's a conversation I'm afraid goes a little bit beyond my area of expertise in employment law, as far as what benefits, what the gamut of benefits might be, what might be easier to offer at a lower price point. But that's my thought. That's what I see smaller employers doing.
And just like from a chamber's perspective for this question, a lot of the businesses that we see doing really well, this is a culture question. So just feeling like they love going into work and they are aligned with the culture and the values that the organization has goes a long way around here. Even if you can't always afford some of the things the bigger companies can. But there's some policies in our family forward guidebook that help with that too, like set schedules and things like that if you want to take a look. There's another question here, Tina. Does vacation carry over or use it or lose it every year?
So if you're a private entity, again, nonprofit or for profit, you cannot have a forfeiture of vacation that has been earned. So whether that's at the end of employment or whether that's year to year. So you do that has been a question for a long time in Colorado, and that's been resolved by some court decisions that the Colorado Supreme Court made and some rulemaking that Colorado Department of Labor did to follow those court decisions in the last couple of years. So no forfeiture of anything that's earned. What you can do, and what we've recommended that you do for a long time, is you set a cap, right? That employees can earn up to a specific level. If they are not using their PTO or their vacation, they're going to max out and they will not continue to earn above that level. And that is a way to keep your costs down as an employer, but you cannot wipe out any vacation or PTO under the current rule as a private employer in Colorado once the employee has earned it.
Okay. And then what are the best ways from your clients to attract and retain with such a shortage of employees?
Well, I think Cece's made an excellent point about culture, right? You also have location going for you and working a little bit against you, right? And the cost and the availability of housing and those things. But you have that. I think offering flexible schedules that Cece talks about is another thing. That remote work is something that many employees want, right? Some of the great resignation is as a result of not having that option to continue to work remotely. Survey your folks. What keeps them working for you, right? What do they value most about your culture, your business, your benefits, whatever it is, and do that, right? Talk about that. I know that loan forgiveness is another benefit that my company's looking at, for a lot of people maybe coming out of school with student loans. Tuition reimbursement, we have a tuition reimbursement, but that doesn't get used very much. So we're looking at loan forgiveness. We added pet insurance in the last few years because lots of people love their fur babies and they appreciate having that as a benefit. So those are some things that I've seen as newer in the area of benefits. If you can have cutting edge benefits. Cece, I don't know if you have any other thoughts there.
I added in the link to our Family Forward guidebook. It says family forward, but it includes all families, even if it's just you and your dog. But it has some actual sample policies that are written that you could pretty much take from there and put into your employee handbook with a few tweaks. Tina helps us look it over, so thank you for that. But if you guys want to check that out, and that is actually also the April 13th session, we have Reach coming out to kind of talk about how you can implement some of these smaller guidebook policies. So not adding a childcare unit into your business, but some of the easier ones that everybody can do. I love the creative thinking with the pet policies and things like that. I am hoping to track some of those this year as businesses are looking to do something different for everybody to pull from, because it truly is what's making people successful. One more question. What would be an example of how you would set the cap for an amount of vacation an employee can earn?
So a lot of times the policy will have an annual amount that they might earn based on their years of service to the company. Very often what I'll see is that the maximum is just a little over that cap. Maybe it's 10, 20, 30, 40 hours over that cap, so that as they carry over year to year, they can still earn some, right? Before they're capped. So that's usually what I see, is something just a little bit above the annual accrual at your different levels of vacation or paid time off.
Perfect. And then for family, you stated 10 employees. Is that at one time, payroll determined, or over the whole year?
That's a good question. I don't actually, I think it's on the payroll. I want to say it's going to be on the payroll, because they're trying to model it after the federal Family Medical Leave Act, and that's on the payroll. There may be, and I'm speculating here, like the federal law, it's not that you become immediately covered as soon as you hire your 10th employee. There might be a threshold of a certain number of weeks that you have to have 10 or more employees. But they were definitely very clear that they don't have to be 10 or more in Colorado. Like if you employ people in Wyoming, right, you're near the border, right, that's going to count towards your 10, right, to determine if you are covered. Again, only your Colorado employees will need to be offered family leave and be eligible to draw from the state system, but your coverage is going to determine based on how many employees you have anywhere in the US, I should say.
Perfect. Thank you, Tina. Does anybody else have any last minute questions, as we're a little over time now? It looks like that's the last of them. So I want to thank you, Tina, so much for your time and your expertise on this. I'm excited to work with you again later this year. And thanks everybody for joining. Have a great day.
All right. Take care, everybody.